Hello, my name is Nurina Fahana binti Ahmad Razif. I am from April 11460. Today, me and my group would like to talk about delay and extension of time. Okay, what is delay? Delay is time overrun from the specified date stated in contract or beyond the date that both parties have agreed upon for delivery of the project. From the owner's perspective, there will be loss of revenue through lack of production facilities and rentable space or dependence on present facilities. Next is from the contractor's perspective. The higher overhead cost is due to longer work period, higher material costs through inflation and labor cost increases. However, delay will cause drop in building activities, reduce efficiency of available resources, and limit the growth potential. The relevant delay can also allow the contractor to request for extension of time. Construction delays will always be considered as time in lag in completion activities from its specified duration of time as per contract. It can also be defined as late completion or late start of activities to the baseline schedule and affecting specified costs. Okay, here are the example of PWD and PALM contract 2018 with quantities. Here are the delay and extension of time clauses. There are two clauses, which is PWD Form 203A and PALM Contract 2018 with quantities. Firstly, PWD, which is Clause 43.0, delay and extension of time, and Clause 50.2, which is extension of time. Based on PALM contract, there are 11 clauses. Firstly, Clause 23.0, extension of time. Clause 23.1, submission of notice and particular for EOT. Clause 23.2, delay by nominated subcontractor. Clause 23.3, insufficient information. Clause 23.4, certificate of EOT. Clause 23.5, other consideration of EOT. Clause 23.6, contractor to prevent delay. Clause 23.7, notification to nominated subcontractor. Clause 23.8, relevant events. Clause 23.9, EOT after the issues of certificate of non-completion. Clause 22.10, architect's review of EOT after practical completion. There are three types of delay categories. Firstly, delay caused by contractor. Second, delay caused by the unpredicted situations. And lastly, delay caused by clients or SO. Okay, here are the delay caused by the contractor. Delay that comes from the contractor's mistakes cannot be accepted and there will be no extension of time issue stated in clause 43 from PWD Form 203A. The contractor will not be awarded extension of time or reimbursement of loss and expense caused by the delay. For example, poor communication and coordination, lack of safety, rules and regulation, and poor site management and supervision. Next, the employer is entitled to LD stated in PWD Contract Clause 40 called as liquidated assistant damage for the time when practical completion of the works is delayed once contractual procedures have been completed. Clause 43 provides that contractor is responsible in taking any steps to avoid reduce the possible delay. Delay that caused by the unpredicted situations. Usually, the contractor will be awarded an EOT only. The employer cannot levy LD. The financial burden of such delay is usually shared by the parties which will be no loss and expense for the contractor and no right to LD for the employer for the period of delay. An example for unpredicted situation is exceptionally inclement weather. This is because it is an excusable delay that would entitle the contractor to an EOT but with no additional money for its effect on the process of works. Unexpected situation is neither the contractor or the employer's fault, so neither the employer should benefit from LD nor the contractor should benefit from loss and expense. Both contractor and employer bear some risk. There are a few relevant reasons in the clauses. A. Force majeure. B. Extreme weather. C. Delay on part of nominated subcontractor and supplier. D. Suspension of work. Here are the delay caused by the clients or SO. Usually it happens because of client's failure response following changes in scope and material. Delay under this category is valid to issuing extension of time. For example, contractor does not receive any instruction, plan enable. Next, delay in giving site possession to contractor. Last but not least, delay on artists, tradesmen, or anything that is engaged by the government in executing work not forming part of this contract. Here is the example of relevant reasons from clauses PWD Form 203A and PALM 2018. Firstly, exceptionally inclement weather, delay in giving site possession, the contractor's inability, delay on the part of nominated subcontractor and nominated suppliers to perform their works because of subclauses A to I. Next is delay on the part of artists, tradesmen, or anything that engaged by the government in executing work not forming part of the contract, which is force majeure, that is provided under clause 58. Next is the contractor does not receive in due time instruction. Lastly, suspension of works under clause 50. Here are the effects of delay. There are a few effects of delay, which is time overrun, cost overrun, idling resources, lawsuit and disputes, and abandonment. The construction project may be regarded as a successful endeavor until it satisfies the cost, time, and quality limitations applied to it. However, it is not uncommon to see a construction project failing to achieve its goal within the specified cost, time, and quality. Delay in construction has negative effects on clients, contractors, and consultants. This is in terms of growth in adversarial relationships, litigation, arbitration, cash flow problems, and mistrust. Okay, that's all from me. Now is my friend's turn, which is Nur Atira Najia binti Abu Bakar. Thank you.
Thank you, Rina. Hi and Assalamualaikum. My name is Nur Atira Najiha binti Abu Bakar and I'm going to explain about extension of time. Okay, so this is the content for extension of time. What is extension of time? Extension of time is a construction period that need to be extended to a new completion date. Function dia untuk bagi lebih masa kepada kontraktor untuk siapkan kerja yang delay. In reality, there are so many challenges that could delay the construction project, macam tak cukup material, and macam keadaan sekarang, kita alami pandemic COVID-19, which kita tak boleh nak jangka benda tu akan jadi. So, banyak construction project sekarang tengah delay sebabkan COVID-19. Sebab kita kan tak boleh kerja, so construction project pun delay lah. So next is the ground for extension of time. The first one is a force majeure. Maksudnya benda yang di luar jangka. Untuk relevant event ni, kita tak boleh nak salahkan mana-mana parti sebab benda yang berlaku tu adalah luar jangkaan kita. Contohnya seperti perang, crime and COVID-19. Kita tak boleh salahkan mana-mana parti sebab benda yang berlaku tu luar jangka. Okay, yang kedua, exceptionally inclement weather. Setiap ujung tahun kat Malaysia akan mengalami musim tengkujuh di mana akan berlaku hujan yang sangat lebat. So, the contractor need to refer the statistic from the nearest weather station from the construction site. Okay, yang ketiga, loss or damage caused by specified risks. Contohnya, saya boleh bagi adalah seperti kebakaran, banjir, gempa bumi dan lain-lain. Untuk relevant event ni, yang kita perlukan ialah police insurance untuk cover kita punya kerosakan harta benda di site. Okay, yang keempat adalah delay in supply of information from CA for which the contractor has made a timely application. Okay, this event occur when there is miscommunication between contractor, NSC and clients. Usually, miscommunication ni boleh dielakkan dengan menggunakan detail critical path schedule yang digunakan untuk susun jadual kerja di site. Okay, seterusnya, deferment of date of possession of site beyond the period stated in the contract. Okay, this relevant event only applies when the employer does not defer possession beyond the maximum period allowed in the contract. Penangguhan ini akan efek kepada work in progress di site tetapi tidak akan extend the contract period sebab ia akan berlaku di date of possession and completion sahaja. Okay, next, delay or failure in supply of materials by the employer. Maksudnya, construction progress tak boleh dilaksanakan kalau ada material yang tak cukup. Material yang tak cukup adalah masalah besar dalam mana-mana construction project. Kontraktor juga perlu bayar gaji pekerja walaupun tak ada barang, walaupun pekerja tu tak boleh nak buat kerja. Tapi kontraktor kena bayar juga sebab diorang dah datang dekat site. Okay, yang ketujuh, delay on part of NSC or supplier. Okay, if the NSC fails to complete the subcontract work within subcontract period, ia dipanggil delay on the part of sebab cuma kerja NSC je belum siap, bukan kerja main contractor. Okay, last but not least, delay due to work convert by a provisional quantities in the BQ proves not to be accurate forecast of the work required. Okay, the provisional quantity roughly underestimate the amount of work actually required. Contohnya macam piling. Kita tak tahu exact amount of pile yang kita perlu gunakan. So, if amount of pile tu lebih daripada kuantiti yang ada dalam kontrak BQ, kontraktor kena buat additional work. So, benda tu pun boleh menyebabkan delay. Okay. Next is the procedure of extension of time. Procedure number 1 is a notice of the issue that causing delays and application of EOT. Okay. The contractor need to apply the extension of time as soon as diorang sedar yang progress of work tu dah delay. Kontraktor juga perlu extend performance bond and insurance sampai mereka tahu tarikh baru untuk completion. Okay. Procedure number 2, assess the application for EOT. It is the SO duty to review the extension of time application based on the supporting details submitted by the contractor. Then the SO will assess and quantum of delay as allowed and acceptable grounds in contract. Procedure number 3, contractor eligible for EOT. Okay. Kalau Kalau kontraktor tu layak untuk dapat EOT, SO akan tentukan new date for completion. Okay, procedure number 4, prepare report of delay and EOT. Lepas kontraktor dah layak dapat EOT, kontraktor kena sediakan report untuk delay and EOT berserta dengan grounds, quantum and calculation. And procedure number 5, check and submit report of delay and EOT. After dah prepare report tu, kontraktor kena check and submit report delay and EOT, and kontraktor perlu tunggu approval from SO. Okay, procedure number 6, approval. Okay, so if kalau report tu dah approve, proceed to procedure number 7. Okay, procedure number 7, kontraktor need to prepare certificate of delay and EOT for approval dari authority pula. Okay, procedure number 8, issue certificate of delay and EOT to the contractor. Okay, after the certificate dah approved by the authority and issue dekat contractor, the certificate of delay and EOT akan memaklumkan tarikh baru untuk completion. Okay, procedure number 9, completion of work is delayed and there is no matter entitling the contractor to an EOT. Maknanya tu salah kontraktor. Kontraktor yang tak siapkan kerja tu pada masa yang telah ditetapkan. Okay, so these are the example of delay and EOT certificate by JKR. Okay, application untuk PWD sama je macam saya explain dekat procedure of EOT. Okay, tetapi berlainan untuk PAM. Okay, untuk PAM, kontraktor perlu sediakan notis yang mengatakan ada kerja yang delay. Lepas tu kontraktor akan serahkan notis claim kepada arkitek dalam masa 28 hari berserta dengan sebab-sebab delay. Okay, dalam masa 28 hari tu, kontraktor akan hantar final claim dan dokumen kepada arkitek. Kalau dokumen tu tak puaskan hati arkitek, arkitek akan minta further document, maknanya ada supporting document yang mengatakan kerja-kerja delay tu. Okay. Okay, after that, the architect need to consider if the notice event causing delay and if they are possible to cause delay to the completion date. Okay, if so, the architect must give an EOT by fixing the new date of completion. Okay, within 6 weeks of the document submission, the architect will issue the certificate of EOT kepada kontraktor. Presenter yang seterusnya akan terangkan tentang claim for loss and expenses.
Thank you, Atira. Assalamualaikum. My name is Shifa Nashuha. I will explain on claim for loss and expense. Under this section, contractor has right to claim any loss or expense incurred because the delays. However, the sum must not under any provision of contract. Okey, kita bagi contoh. Contohnya kerja frame yang tertunda. So, contractor nak claim untuk charge sewa plant and machineries. Boleh sebab charge sewa kan ikut masa. Jadi, bila dah jadi delay, kos tu tinggi. Melebihi apa yang telah provide dekat dalam kontrak. Jadi, contractor berhak nak claim. On this slide, this is clause 44.1 PWD and clause 24.1 PAM. But the reason of delay is only acceptable based on clause 43.1, which is number 1, suspension of works under clause 50, iaitu pergantungan kerja atas arahan SO. Maka kontrak kena stop sementara daripada buat kerja tu. Next, number 2, SO instruction issue under Clause 5. Clause 5 ni dia cerita arahan SO, apa-apa arahan SO kena patuh. Contohnya ada perubahan drawing ke, perubahan specification, so kontraktor kena ikut. Jadi kadang-kadang perubahan ni dia akan menyebabkan delay. Number 3 is direction given by the SO consequential open disputes with neighbouring owners provided the same is not due to any act or negligence or default of the contractor or any subcontractor nominate or otherwise. Kadang-kadang arahan SO ni dia akan menyebabkan pertikaian antara owner. So, bila ada pertikaian, kerja tak jalan sebab tak dapat keputusan yang mutamat untuk apa yang nak jadi dekat building tu. Move on to number 4. The contractor not having received in the due time instruction in regard to nomination of subcon or supplier, or provide contractor the necessary instruction, drawing or level execution of the works from SO due to SO negligence. Jadi, bila kontraktor tak dapat masa yang cukup, peralatan yang cukup, arahan yang mencukupi, dia terpaksa start kerja lambat. Bila start kerja lambat, dia akan siap lambat. Last but not least, number 5. Delay on the part of artists, tradesmen or other engaged with government in executing work not forming part in this contract. So, bila tukang kayu ke, tukang yang dilantik khas oleh kerajaan tak buat kerja, yang menyebabkan kerja kontraktor tu tertangguh, jadi kontraktor berhak nak claim loss dia. Okay, on this slide, it is on PAM contract, like what has our beloved friend Tira has explained before. Comparison between PWD and PAM is notice of claim. Both contract, PWD and PAM, mention the same direction for contract to give a written notice to SO or architect, but PWD give 30 days to contractor in occurrence of the event, but PAM give only 28 days to contractor settle the notice. Next, detail of claim. It means that contractor should provide evidence of his claim, such as supporting document, explanation, calculation, or report. On behalf of PWD, it must be done as soon as it practicable, but not later than 90 days after practical completion of the work CPC. But PAM, the contractor shall send to the architect or QS a complete particulars with all necessary calculation 28 days. And then contract sum. Under clause 44.3 PWD 203A state that amount of such direct loss or expense ascertained by the SO shall be added to the contract sum. And PAM under clause 24.4 also mention a same statement, but if an interim certificate is issued after the date of ascertainment, then amount shall be included in the certificate. Why SO or architect need the evidence? It is because the particular evidence help them to ascertain or verify the claim of contractor. It is important to determine if contractor tell the truth or not. Lastly, contractor failure. If contractor fail to follow the regulation of contract, PWD and PAM, then they can be counted as fail or waiver his right for loss and expense claim. One more thing. On PAM 2018, clause 24.2 is mentioned about access to contractor's book and document, which is the contractor shall keep contemporaneous record of all his claims for loss and expense and need to submit it to the architect. The architect and QS have an access to all books, document, reports, paper or record in possession and custody or control of the contractor that are material to the claim. Contractor shall provide free of charge a copy of each to the architect and QS when requested. All of the documents shall remain available until all claims have been resolved. The contractor shall use his best to ensure that all such documents in the possession, custody or control of the subcon and or suppliers of the material to the claim are available. Alright, that's all for my group. Thank you guys for watching. And Selamat Hari Raya Aidilfitri, maaf zahir dan batin. Assalamualaikum.